Fellow Ghanaians, good morning. And this morning, I want us to confront something that should never have become a controversy in a secular democratic republic that claims to respect its own constitution. A controversy so needless and so telling that it forces us to ask what kind of society we are trying to build and what kind of republic we truly are beneath all the rhetoric. I'm referring to the ongoing attempt by the Attorney General, supported by a certain group of so-called public intellectuals and a handful of elite voices, to justify the restriction of Muslim students' religious freedoms in schools that are publicly funded, publicly regulated, and publicly mandated to serve every Ghanaian child without discrimination. It is a debate that reveals both a legal crisis and a social sickness, and the two cannot be separated because the law does not operate in a vacuum. It is always reflective of the moral clarity or moral confusion of the society it seeks to govern. So, fellow Ghanaians, let's begin by being really frank with ourselves. The Attorney General's submissions in defense of Wesley Girls Senior High School do not reflect a faithful interpretation of the Constitution. Simple. And neither do they reflect the principles that should guide the Republic's chief legal officer. Instead, they reflect a political instinct to avoid a discomfort, a desire to protect an old elite practice rather than defend the constitutional egalitarianism, and a willingness to stretch legal reasoning to set absurd levels simply to avoid facing the truth that the Constitution protects students, not institutions, the rights of human beings, and not preferences of administrators. Fellow Ghanaians, the Constitution is unambiguous. It guarantees that every Ghanaian shall enjoy freedom of religion, freedom of conscience, freedom to manifest their faith in worship, in practice, and in observance. These rights, fellow Ghanaians, they are not suspended by the school you attend. They do not evaporate when you enter some dining hall. They do not depend on the Methodist Church's heritage. They are not negotiable. They are not diminished by the ethos of any mission school, because mission schools are not churches. They are not private theological seminaries. They are public educational institutions built on land acquired by the state, funded through taxes collected from Christians, Muslims, traditionalists, atheists, and operated under state regulation and integrated into the national payment system. So when the Attorney General frames Wesley Girls School as a religious body with a right like that equal to those of private faith institutions, I suggest strongly that he misleads the public and misstates the law. Because the Wesley Girls School is not a private congregation. It is a state-supported school that must educate every Ghanaian child without discrimination. The AG knows this. The Deputy AG also knows this. And every serious lawyer knows this. Yet they rely on cases that do not apply. They cite precedents out of context and then ask the Supreme Court to privilege institutional preference over constitutional supremacy. Fellow Ghanaians, let's take the Bonfe case, which the AG holds up like a shield. The case dealt with the state involvement in religious initiatives, but did not say that religious institutions funded by the state may violate the rights of individuals under their care. It did not declare that mission schools may suppress religious freedoms of their students simply because those schools were founded by a church. It certainly did not say that publicly funded spaces may be turned into denominational enclaves. Yet the AG leans on that case as if it hands mission schools a blank check, something the Supreme Court never intended. Then there is the Loyola High School case from Canada, which the AG again uses as if it grants schools the power to restrict the religious rights of students. But that case, again, has nothing to do with student freedoms. It dealt with a private school's right to teach religion in a manner consistent with its own doctrine. It did not grant the school authority to prevent students from practicing their own faith. It did not empower institutions to claim that their ethos overrides individual constitutional rights. It addressed curriculum, not oppression. And because Wesley Girls is not a private Catholic school, but a publicly supported Ghanaian institution, the AG's reliance on that case as a precedent and that foreign decision reveals not just legal insight, but legal desperation. In fact, when both cases that I've cited are properly analyzed, when one carefully separates the context and the purposes of those judgments, what emerges is the opposite of what the Attorney General is foisting on the Supreme Court. Both cases affirm that the state may work with religious organizations, but must always protect the rights of individuals, especially when those individuals are within state-funded environments. So, for Ghanaians, the question is simple. Does the Constitution protect the rights of Muslim students to pray, fast, practice their faith in a publicly funded school? Yes, it does. Does Wesley Girls have a right to impose denominational purity on its students? No, it does not. Does the state have the power to deny students their religious freedoms in order to protect an institution's institutional beliefs or historical preference? Absolutely not. And can public money be used to enforce discriminatory practice? Never. So, does the Attorney General's logic, if adopted, and as we see, it risks creating a future where schools will enforce doctrinal segregation? Without question, that is what is going to happen. And this is what makes the Attorney General's stance so dangerous. Because if the Supreme Court were to accept the argument that mission schools may restrict the rights of students, then Catholic schools may ban Muslim worship. Islamic schools may also in turn ban Christian prayer. Presbyterian schools may ban charismatic prayers and expressions, and then we will have turned our public education system into a patchwork of religious fortresses that is policing the faith of teenagers, young people. That is the collapse of pluralism. That is the collapse of the rights of people to express their faith. And that is the collapse of equality under the law. Fellow Ghanaians, this is not how nations that want to develop into something do. This is how you slide into intolerance. And it's not always by some loud explosion, but by the quiet legitimization of such institutional discrimination dressed up as tradition. And the Attorney General, in taking this position, is not just misreading the law, he's failing the Republic. Because justice in his title should compel him to protect citizens from discrimination and not defend institutions against right claims. Now let me move to the second part of this episode, perhaps a bit long because of the very important nature of this matter. And if you look at this second part, it is even more painful than the first, what I just talked about the law, because it exposes something profoundly worrying about who we are becoming as a people. When this issue first came up, and even more so now that it has reached the Supreme Court, we have seen an avalanche of commentary that is not only intellectually shallow, but morally disturbing. Commentary laced with prejudice that has been wrapped in some elitism and dressed in the language of bigotry, tradition to mask what it truly is, bigotry. There are public intellectuals, people who claim to defend human rights, who suddenly have lost their sense of justice because the individuals seeking fairness happen to be Muslim students. There are lawyers who build straw men so flimsy that one wonders whether they even read the Constitution. There are so many people that are saying so many things that are simply unfounded. They are commentators who reduce the debate to absurd hypotheticals about goat slaughter in classrooms, as if Muslims were asking to pray 5 times a day or to fast in such an environment is equivalent to ritual sacrifice. Why is it then that when we talk about religious freedom, we never imagine the elegant Catholic Mass or the quiet Presbyterian hymn as the scenario that must be accommodated. Why is it always African traditional religion that gets dragged as a caricature? What is it about our own religious imagination that tells us some faiths are respectable and others must be mocked? And even worse, there are people who are asking if Wesley Girls Senior High School will collapse because a handful of Muslim students want to pray. What exactly is the fear? That the Methodist Church will fall? That the school's identity will all of a sudden evaporate? That the ethos that has been built over a century will all of a sudden crumble because some teenagers kneel down and pray? Look at this. This is not a clash of cultures. It is the unmasking of prejudice that has been there all along. And the argument that mission schools must enforce homogeneity misses the whole point of national integration. Our public boarding school system was built to mix tribes, faiths, to mix cultures, to mix backgrounds, to loosen the grip of narrow identities, to create citizens who could understand differences and respect it. Yet now the state is defending the creation of religiously exclusive education zones, turning secondary schools into denominational enclaves. Fellow Ghanaians, how does that serve a diverse nation like ours? How does that serve unity? How does that prepare our children to live in a pluralistic republic? Why is the state encouraging the very fragmentation it sometimes claims to oppose? Why do we spend so much money sustaining an integrated public education system only to undermine it by allowing schools to restrict basic rights? Why are we telling Muslim girls that they must choose between quality education and their faith? Why are we telling their parents that their children's constitutional rights end at the school gates, at Wesley Girls or anywhere for that matter? And then there is the most cynical line of all of this. And I quote, if you cannot practice your faith at Wesley Girls, then go somewhere. But how is that realistic? When the state itself decides the schools that students must be placed in, how is it fair when Muslim students do not have access to alternative schools of equal quality like the Wesley Girls? How is it just when the best schools can sometimes be mostly mission schools, TIMAS, Wesley Girls, and Fancy Pim School? How is it decent for the state to say, well, we know the system gives you no real alternative, for instance, but we will pretend and put you anywhere of those places? Look, Ghanaians, that is the big issue we need to confront, the discrimination. The issue, fellow Ghanaians, and don't lose sight of this, it's not about Methodist values. It is about control. It is about power. It's about tradition being protected at the expense of rights. And too many of our thinkers are defending this because they cannot imagine a Ghana where religious equality is more than a slogan. Fellow Ghanaians, in all of this, even more painful is that some of the fiercest defenders of this discrimination are themselves people who will never tolerate such treatment for their own kids, for their own children. If their sons were stopped from praying, they will be on every media outlet demanding justice. But because it is someone else's daughter wearing a hijab, they preach discipline. So fellow Ghanaians, this morning, the message is to you, the president. When you campaigned in 2024, you said your government will allow every Muslim student wear hijab. Have you seen the argument your Attorney General is making in court? Does that align with the promise you made to Ghanaians? Fellow Ghanaians, as we end this episode, do not lose sight of the real issue. The issue is not about whether Wesley Girls are Methodist school. It's about whether or not hundreds, young students, boys and girls in all the other schools can simply pray. And if they do, does that hurt the Methodists in Wesley Girls? It doesn't. Students are not asking to build a Kanda-like Muslim mosque in Wesley Girls. They are simply asking for their right to simply fast and pray. How is it fair that young girls will be forced into dining hall when they say they are fasting and be forced to eat? Simply because the school says you are not allowed to manifest your religion. It's about the Constitution or defending such institutional issues. The ball is in the court of the Attorney General and in the Supreme Court. We all hope that the court will live up to the responsibility. This is a major case that will determine a lot going into the future. Good morning, fellow Ghanaians.